We'll hear from the appellate when you're ready.
Good afternoon, Your Honors.
Good afternoon.
My name is Emily Calla. I am with Legal Aid of East Tennessee, and I'm here on behalf of the appellant, Mark Elliott. I would first like to reserve 4 minutes on rebuttal, please.
4 minutes will be fine.
Thank you. This lawsuit arose from maintenance and repair issues in a landlord-tenant relationship under the Uniform Residential Landlord-Tenant Act, which I will refer to as URALTA moving forward in my argument. My client, Mark Elliott, was living with his wife, 7-month-old baby, and 7-month-old child in a residence that he rented from the appellees in the early summer of 2022 when his air conditioning stopped working. The windows in this residence were completely inoperable, meaning they did not open, so the only option that Mr. Elliott had to lower the inside temperatures, which were reaching the high 70s to low 80s all summer, was to be confined to one room with his family, which was, as my client described it, halfway cool enough for them to spend time in. They had to drag their mattresses and kitchen table in and out of the kitchen between the day and night just to be able to use their home for basic functions. Despite months of desperate pleas for help, appellees refused to make repairs while Mr. Elliott's 7-month-old baby suffered seizures and heat rashes all summer. Finally, when Mr. Elliott sought legal services, appellees offered their one and only alleged repair: to remove the residence's front door, cover the opening with an unsecured piece of plywood held up by an unsecured piece of 2x4 wood, cut a hole in the plywood, and insert a window air conditioning unit. This proposal is egregiously outside the bounds of habitability requirements under 6628-304 contained in URALTA. Now, Legal Aid is on the ground in General Sessions Court every week, and we're seeing more and more substandard housing issues similar to this one, and URALTA is becoming increasingly relevant as a larger percent.
Is this a residential residence?
Your Honor, this was a commercial building that was lawfully able to be rented out as a residential residence.
Had it ever been proclaimed in any way or recognized in any way as an actual residential residence?
Yes, Your Honor. In fact,
And when and how?
just through the lease agreement.
Through the lease agreement?
Yes, which was in place for 10 years prior to this situation.
And the lease agreement actually defined this dwelling place as a residential residence?
Yes, Your Honor. And the circuit court and then the General Sessions courts both agreed, as well as the appellant and the appellee are on the same page that this was able to be rented out. There was nothing in any local codes that prohibited its use as a residence, despite being zoned for a commercial property.
Okay.
Thank you. So the terrifying emergency circumstances that my client faced are typical of the issues that we litigate. So we're here to clarify really two main issues that are crucial to my client and to many Tennesseans across the state that rent. So first, we need clarity about the power of the General Sessions Court, specifically their powers to issue injunctions, to be able to issue penalties for failure to comply with injunctions, and the force and effect of such an order from a General Sessions Court and regarding whether that injunction actually remains in place on appeal from the Sessions Court to a higher court. Additionally,
I need some clarity on that argument because I frankly don't understand it. To me, it appears to be completely contrary to the black letter law that says we know Sessions is not a court of record. And we know that once something is appealed from Sessions to circuit, it does proceed as a brand new trial. So I'm having a hard time understanding the argument that you're making to the contrary.
yes, Your Honor. So this is a very unique situation because Tennessee Code Section 1615-401 gives the General Sessions Court the same authority to grant injunctions as the circuit and chancery courts. So if the appellees wanted to challenge the order before they were able to be found in contempt of the order, they would have had to file a writ of certiorari and supersedious in July.
Let me stop you there, too, about the order of What order of contempt are we talking about? Because I don't see in the record any pleading for contempt or any finding of contempt.
Yes, Your Honor. So in General Sessions Court, as you know, and we've cited the Ware versus Meharry Medical College case to state that General Sessions Court is an informal court. So even though all of these requests were made verbally, which is the general practice in General Sessions Court, and the ruling by the court was verbal, aside from the monetary judgment that they entered, there was a request for a finding of contempt. So it is appellant's position that this is kind of the issue that we're trying to bring forth to the court, is that the General Sessions Court is in this area that the law does define what needs to be done when the General Sessions Court finds that there's contempt. It's just there is not a sufficient record. So when this went up to the circuit court mistakenly applied the de novo standard to this, even though that is not the standard for reviewing a finding of contempt.
Okay.
All right, now I'm confused. Why is it not the standard of review?
Because per State versus Jones, a finding of contempt must be upheld even if the order which the contempt was based upon is later found to be erroneous.
Do you have any cases where this has happened, where you've had a finding, let's just assume there is a finding of contempt, because I'm not
Yes.
entirely convinced that there was, but let's assume that there was in Sessions, and then that whole case gets appealed up to circuit. Do you have any case law that says the contempt travels with, that the black letter law that says it's a brand new trial doesn't apply specifically to contempt? Are there any Tennessee cases that say that?
Well, State versus Jones does say that the contempt finding must be upheld in PNC, multifamily capital institutional fund, limited partnership versus Bluff City Community Development Corporation, says that the disobedience of a valid though erroneous and reversible order is a contempt of court. And as long as the court had proper jurisdiction, its order is valid, though it be erroneous, and disobedience of the order is a contempt of court. So although that doesn't address it going up to appeals, it does, there's no case.
That's kind of the key difference, though. That's kind of what makes it important.
Yes. So I guess, the underlying effect of saying that the General Sessions Court's power that is supposed to be equal to the circuit court and to the Chancery Court, by holding that their contempt isn't as powerful as the other two courts' contempt, that is therefore making somebody that goes to the General Sessions Court at a disadvantage compared to the other two courts when their powers are supposed to be the same.
Okay.
And I think that's time.
All right, but the cases that you cited there
Yeah.
in support of your argument, the appeal is not, did any of them involve a de novo, I mean, a brand-new trial, what's provided for a de novo trial? Or was it an
No.
appeal?
There's unfortunately no case law from General Sessions Court
Okay.
to Circuit Court, which is why we're seeking clarity on this issue, because in landlord-tenant law, tenants do go to the General Sessions Court almost exclusively for their injunctive relief.
Yeah, those cases involved a contempt finding in a circuit or chancery court, and then it was appealed to us.
Yes.
Okay.
Yes, Your Honor.
All right.
I think. Okay. And essentially, what the circuit court's ruling is allowing, and allowing the circuit court to review this case de novo, is that it puts the power in the hands of the contemnor to basically get a get-out-of-jail-free card and walk to the clerk's office, file an appeal, and then it just washes away the court's order, takes away all of the force and effect of the court and the power that they held, and it...
That is exactly what it does.
Yeah.
But, I mean, we didn't draft it, that's what the legislature said it should say.
Correct. And I think that the statute that grants the General Sessions Court the same power as circuit and chancery needs to be interpreted in conjunction with the underlying purposes of injunctive relief, which is really to address the most high-risk, time-sensitive situations that it would, in this situation, what if my client's baby was not just having seizures? What if he passed away during the pendency of the appeal because there was no air conditioning? Then the appeal would just wash away any contempt that could have been had if the circuit court decided that the injunctive order was not proper. And,
I think the law kind of says what it says.
all right.
I understand your point, but
Yeah,
we're
that's-
not policy people.
Okay. I would like to just use the remaining small amount of time for my last issue, which is the written notice issue. And the circuit court ruled that the lack of written notice that my client gave prior to filing this lawsuit made it so that this case could be dismissed on its face. However, Uralta specifically was amended by the legislature to add 6628-302 to state that a landlord must provide an address to a tenant before they start a lease agreement. Now, that was added after this lease agreement was entered into, but it speaks to the legislature's intent that they would not allow for a landlord to essentially absolve themselves of being able to be held accountable for breaching these maintenance and repair statutes, which are arguably some of the most important statutes in Uralta, by failing to give an address either purposely or unpurposely. And additionally, though the court did say this is a plain reading of the statute, in Lipscomb versus Doe, the court ruled that where the plain language of the statute leads to an absurd result, this court looks beyond plain language to adopt a reasonable construction. So the underlying purposes of Uralta are outlined in 6628-103, and it said that it's to be interpreted broadly and liberally to encourage landlords and tenants to maintain and improve the quality of housing. So we think that in these very narrow circumstances, the court needs to rule that no written notice is required. Thank you.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
Good afternoon, Your Honors. My name's Ben Houston. I represent the appellee, David Wright, in this case. I also represent Patricia Wright. As this court knows, there was a notice, a suggestion of death that was filed, sadly. In this case, Mr. Elliott, I guess, began leasing this unit from my clients in June of 2013. And I guess the issues that led to the litigation began around April of 2022 when Mr. Elliott alleges that the air conditioning unit stopped working. The testimony at the circuit court trial in this case was that Mr. Wright had offered to fix the air conditioning unit by taking out the front door and placing a large air conditioning unit in the space where the front door was situated. Now, it's important to note that there were 3 doors to this residence, so that was not the only door. There were 3 doors where the tenants had ingress and egress to and from the residence. And so using the front door to install this air conditioning unit, a large air conditioning unit, which could have possibly resolved this issue, would not have prevented my clients from, or excuse me, the appellant from entering and exiting the residence. The appellants filed their verified complaint on July the 1st of 2022. There was an ex parte emergency order. I think it's important to note this was an ex parte order that was entered without any prior notice to my clients, without them having an opportunity to contest that. And then ultimately, on September the 20th, the Knox County General Sessions Court entered a monetary judgment. That monetary judgment does not say anything about the ex parte order continuing, and it also doesn't say anything whatsoever. The words contempt don't appear anywhere on that judgment. There's no explanation on the judgment itself as to how that award for damages was come to by the General Sessions Court. And I think it's important to note that when appellants are before this court, it's the appellant's obligation under the rules of appellate procedure to prepare a record that allows this court to enable reviews. So to the extent that there's some claim that there was something in the order from General Sessions Court that's not before this court, there's no transcript from the General Sessions Court hearing. There could have been a transcript filed, perhaps. That wasn't done. That's not the appellee's job. That's the job of the appellant to make sure that there's an adequate record on appeal if they're going to raise an issue. But the fact is, the General Sessions Court order, the final order that was appealed, contains no reference whatsoever to contempt. Obviously, there was a timely appeal from the General Sessions Court order to Circuit Court. The Circuit Court held a de novo trial, which is what the statute provides and what the case law provides, pursuant to this court's case law, McGee versus Jacobs, Ware versus Meharry. It's very clear that in Circuit Court, an appeal brought pursuant to this section, and this is a quote from the McGee versus Jacobs opinion, the Circuit Court does not review the General Sessions Court's disposition of the matter, but hears the matter as if no other trial had occurred and as if the case had originated in the Circuit Court. That is the case law from this court, quoting the Tennessee Supreme Court in Ware versus Meharry. With regard to the damages for contempt, there's never been a contempt pled in this case. The first reference to contempt I could find in the record, other than an admonition to trial counsel, and I was not trial counsel, but an admonition to trial counsel about contacting a represented party. The first reference to contempt in the record at all is a post-judgment Rule 59 motion. Contempt, the word contempt wasn't even uttered at the bench trial that was held in this matter. And it's well established you can't raise issues on appeal that were never raised at the trial court level, nor can you do so for the first time in a Rule 59 motion. Your Honors, the Circuit Court also acted within its sound discretion by determining that the plaintiff, in this case, failed to prove that he was entitled to any relief on the verified complaint for the ex parte injunction. As I've already mentioned, there was no reference at all to contempt. There's no filing of contempt, no pleading. There was no petition for contempt that was even filed in the General Sessions Court after the ex parte order was.
Let me ask you this, Mr. Houston. Like, getting more to the substantive issues that were tried in the Circuit Court. Yes, Your Honor. You raised the issue of the lack of written notice. Do you think that carries the day, or do we need to? Is it a factor that we consider with everything else, or is that dispositive? I think it's dispositive, and I did plan to get there, but I'll go ahead and get there, Your Honor. Absolutely. I do think it's dispositive. 6628-502C states, quote, "The rights under this section do not arise until the tenant gives written notice to the landlord and has shown that the condition was not caused by the deliberate or negligent act or omission of the tenant, a member of the tenant's family, or other person on the premises with the tenant's consent." The important words there being written notice, and that's required. Are you aware, Mr. Houston, of any case law that says that language can be modified by the party's course of dealing? Because I kind of think that's what your opposing counsel is arguing. I'm not aware of any case law that says that can be modified by the party's course of dealings.
Are you aware of any case law that says to the contrary? That it can't be, that requirement for written notice can't be waived or can't be modified by the party's course of dealings? I mean, are any cases on it one way or the other?
Not that I'm not aware of any case law that's specifically on that issue. I am aware of the King Stable, 495 King Stable LLC versus Pate case, which I think does stand for the proposition that where an offer to remedy a situation has been made, the tenant, and that's refused, the tenant cannot then go to court and seek relief based upon that alleged substandard condition. And that's the 495 King Stable LLC versus Pate case. I would say that when it comes to the plain language of the statute, one of the most basic rules of statutory construction is that where the language contained within the four corners of the statute is plain, clear, and unambiguous, there is no room for interpretation or construction, and we must apply the words of the statute. I would also, and that's Purcell versus First American National Bank. There's also a tenet of statutory construction that says that you're not supposed to render the words of a statute superfluous. And so if you take the appellant's position that the written notice is optional under circumstances where the statute doesn't explicitly say that, then you're essentially rendering the word written superfluous, and that violates well-established canons of statutory construction. I would also point out, when we get to the facts, even assuming that this court can consider a contempt that was never pled or tried, the facts don't even support a finding of contempt in this case, I would argue. In particular, the appellant himself testified that the residence consisted, and these are his exact words in the record, of, quote, 2 rooms, a kitchen, and a bathroom. And there was also testimony that the kitchen was situated in a way that there was no door in the big opening that led from the main room to the kitchen. So it was kind of an open layout, it sounds like. So that wouldn't necessarily be a separate room. And then you have the bathroom. I've cited case law in my brief from another jurisdiction that suggests that bathrooms aren't considered for purposes of counting rooms. At the very least, the order is not clear and unambiguous as to whether my client was required to provide more than 2 portable units. There is no question that it's very clear in the record that Mr. Wright did very quickly after the order was entered, in this case, the ex parte order, I should say, he did soon thereafter provide the tenants with 2 portable air conditioning units. To the extent that he was required to provide more, the order is ambiguous on that point, and you can't be held in contempt of an ambiguous order. And I would note that the order didn't have to be ambiguous. The order was actually drafted very clearly by the appellant's attorney in this case, because the order was signed the same day that the petition was filed, and as standard operating procedure, I'm sure that the order was prepared and submitted for consideration at the same time that the filing was made. So they could have made it clear how many air conditioning units they wanted, but they didn't do that. But that's not Mr. Wright's fault, and he can't be said to have willfully violated a court order under those circumstances. In this case, Your Honor, we would ask that we believe that the law is very clear that the circuit court acted well within its discretion in dismissing the case. We do believe in this particular instance that the appeal does fall within the purview of Tennessee Code Annotated 27-1-122 because, quite frankly, it had no reasonable chance of succeeding. And if it was just one issue, perhaps the argument on that might be weaker, but there are a number of reasons why this appeal couldn't succeed. There was the lack of written notice, the fact that contempt was never pled, the fact that the word contempt wasn't even ever mentioned at trial, the fact that the damages that are actually authorized by Tennessee Code Annotated 66-8502, none of those damages were even testified to at trial. There are specific damages that are authorized under that statute, and none of those damages were actually testified to at trial in terms of obtaining substitute housing, diminution in the fair market value of the house. They had the opportunity to present that evidence at trial, but they didn't do that. They didn't present any evidence at trial regarding the statutorily authorized damages set forth by Tennessee Code Annotated 66-28-502. Now, I think in the reply brief they mentioned, well, then the punitive damages are authorized by 66-28-504. But that doesn't work either, because even their verified complaint for ex parte injunctive relief doesn't mention 66-28-504. It only mentions 66-28-502. So, Your Honors, for all of those reasons, the appellee in this case requests this court affirm the circuit court, and we request their attorney's fees on this appeal. Thank you, Your Honor.
Thank you. We'll hear from the appellant rebuttal.
First, appellant would just like to bring forth that Mr. Elliott did ask the circuit court to hold the appellees liable for being in violation of the court's order.
Of the General Sessions Court order.
Yes, yes, and asked also the General Sessions Court, and that was the request for contempt. Further, just to address multiple points brought up by counsel, Ware versus Meharry Medical College says that litigants in General Sessions Courts may plead their cases orally without filing written pleadings, and circuit courts should not dismiss cases originating in General Sessions Courts because of any informality whatsoever. Therefore, despite there being no written request for contempt, the motion for contempt at General Sessions Court has to survive and serve that purpose.
Well, I'm looking at it, I mean, wasn't what you asked for as far as contempt for the circuit court to find that the defendant was in contempt for violation of the General Sessions Court injunction?
So,
I mean,
our position remains that when the statute gave the General Sessions Court the same.
I understand, but what you're saying, the contempt arose from a violation of the General Sessions Court injunction.
Yes, because.
And you asked the circuit court, that was where you asked the circuit court for contempt.
Yes, Your Honor.
Okay.
And that is because there are multiple cases that state that even if an order is erroneous and later overturned, it still remains valid. So that order was put down in July. It remained valid until its merits were heard in October of 2023, or at least arguably until September of 2022. The order did not just disappear. To address a couple more points with the couple minutes that I have. In the PNC case that I brought up earlier, the court is very clear that a court must maintain the integrity of its orders. So that goes further toward why the General Sessions Court having this power to issue contempt and issue injunctive relief at the same level as Circuit and Chancery Court means that those orders need to be treated the same way as they do in Circuit and Chancery. Otherwise, the General Sessions Court does not have the same power as the Circuit and Chancery Court if somebody can just turn around and make the General Sessions Court order disappear, whereas Circuit and Chancery Court would have to be appealed up to the Court of Appeals. And it's not treating things with the same standard that the statute calls for. And as far as the order being ambiguous, there is case law, Blair versus Nelson, I believe, that says that ambiguity does not render an order void. It must be followed until it's reversed. However, it was very clear at trial that this building was testified to have 2 rooms, bedrooms, a kitchen, and a bathroom. As to counsel's contention that a bathroom is not considered a room, the cases that he cited were for tax purposes. However, there are multiple cases that I cited in my brief showing that for purposes of habitability in Uralta, a bathroom is absolutely a room, and if we take the position that a bathroom is not a room, then the landlord would have no liability or duty to take care of it, where
Why does it matter whether the bathroom was a room?
if there was no air conditioning, especially with the temperatures in July, the bathroom could have grown mold, there could have been moisture issues, which then would go against the habitability standards that the landlord has to upkeep. That's time. Thank you.
Court's thanks to counsel for both sides. We appreciate your briefs and your oral argument today. If you would, please adjourn court till 9:30 tomorrow morning.